We are diving straight into the deep end of the legal pool today. We got a defendant claiming she was a victim, a judge who has clearly seen it all, and a paper trail that points to a total house cleaning of an ex-boyfriend's property. But wait for the twist. Later on, we see a teenager get lectured by the same judge for using the N-word in court filings. You're going to want to stick around for that reality check. But first, let's talk about Melanie Barron.
PSI report is this was your boyfriend. He called the police, and the police ends up arresting him. And then when he comes back, all of his items are gone. Let's discuss. That's what I want discussed. Why? And in your writing, you're using the N-word. I bet you were shocked when you saw me here. Right?
Yes, ma'am.
With what Mr. McLaughlin was saying and what he has in writing, that he agreed. You know what? I am not going to sit here and try to overtalk you, because if you keep interrupting me, you're going to be going with my bailiff.
Do you have any clue what they would do to you in prison? Take a guess. You'll be someone's bitch real quick. Really.
All right. Did you review the document entitled Court Admonishments with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with theft, $2,500 to $30,000? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find.
Hold on, let's pause. The judge just mentioned deferred adjudication. For those of you not in law school, that's a legal second chance. Essentially, the court holds off on finding her guilty. If she follows all the rules of her probation, the case gets dismissed later. But, and it's a big but, if she messes up just once, the judge can sentence her to the full maximum of that state jail felony. It's a high-stakes tightrope walk. Do you think she can stay on it for 4 years?
Find you guilty? Court will defer finding of guilt as you've applied for deferred adjudication. We're going to come back on September 19th for your sentencing. Ms. Abrams, there's going to be a PSI and tap on Melanie Barron. All right, once you sign the reset form and speak to probation, you're excused. All right, you entered a plea of no contest to count 1. There was an application for deferred adjudication and community supervision. According to the plea bargaining agreement, punishment was to be assessed at 1 year in the state jail facility. There's a $1,500 fine. The state opposes your application for community supervision or deferred adjudication, and there's to be restitution and no contact with Francisco Vasquez. Have both parties had a chance to review the PSI report and TAP evaluation, and also the DDRF mixed screening results? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to those items? State? Defense?
No objection.
Any witnesses? State? Defense, any witnesses?
Just the defendant.
All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record. All right, make sure you keep your voice up. And everybody in the audience, whisper like you're spies and don't want to be caught. All right, defense. You may proceed.
Ms. Brown, where are you living right now?
At the Balcony Heights, Heritage Apartments.
Okay, and are you living by yourself, or do you have a roommate?
No, I live with someone else.
Okay, you're whispering. You need to speak up.
Yeah.
No, I live with my boyfriend.
Okay.
All right, so let's do this. Don't turn towards the defense. If you'll just speak towards me and keep your voice up here so that the court reporter can hear.
Yes, Your Honor.
And Ms. Brown, can you tell me how you're employed right now?
I work with Block by Block. That's Central, downtown San Antonio.
In what kind of work is that?
I work along the river, the cleaning of the river. We give information and assist those in need.
And how long have you been doing that?
Since August 14th.
And are you employed doing that full time?
Yes, sir.
Okay. And is it your plan to continue working at Block by Block?
Yes, it is.
Okay. Ms. Wren, before this case, have you ever been arrested before?
No,
Do you have any prior convictions?
no,
Ms. Brown, if you are placed on deferred adjudication, will you be able to successfully complete that deferred adjudication?
yes,
Okay. Do you understand that there's an amount of restitution in the amount of approximately $20,000?
yes,
And is that an amount that you will be able to pay back through your probation?
yes.
Your Honor, I'm going to pass the witness for now.
State,
No questions for this witness at this time.
I have a few questions. So what I've read in the PSI report is this was your boyfriend. He called the police and the police ends up arresting him. And then when he comes back, all of his items are gone. Let's discuss. That's what I want discussed. Why would you take his items? Because that's what we're here for. We're here for the taking of items. I don't know if these items are worth $21,000 because nothing has been given to me. But I'm wondering, why would you do that?
Well, I'm at a poor judgment.
The classic, some guy did it, defense. Melanie is claiming she just hired some friends to help her move and they, unbeknownst to her, decided to loot the entire apartment. The judge is skeptical, and honestly, so am I. The legal term here is co-defendant. But notice how her attorney quickly points out she cooperated with the police to get that person's case dismissed. She's throwing the friends under the bus to save herself. Is she a victim of bad company or the mastermind behind the move? Let me know in the comments.
Calling friends to assist me in moving.
Wait a minute, what?
I made a poor judgment, calling a few what I thought was friends to assist me moving out, and they took the items that did not belong to me.
What do you mean they took the items that didn't belong to you?
While I was moving my stuff out, they were taking things and I didn't stop them.
There was a co-defendant on this case, Your Honor.
And what is the co-defendant doing?
That case was dismissed because my client, Ms. Barone, cooperated with the police and the DA's office. You can see that she voluntarily went and talked to an investigator. There's about a 7 or 8 page statement that she's made. And I have to point out that she's been cooperative with the police all along and helping them in their investigation.
All right, so I still don't understand why you would have people take items that didn't belong to you. What was the conversation? You decide you're leaving him while he's at the Bexar County Jail. I'm assuming, hypothetically, if you had a bed, okay, I need somebody to help me move my bed out. So they moved the bed out. Were you telling them what items were yours?
I did tell them what items were mine. I'm coming out of a very stressful situation with this man. He's been very violent. He has abused me. He's assaulted me. He's manipulated me. I was panicked as to what he would do when he returned. So I wasn't paying attention to detail to what these gentlemen were doing. So as they were moving stuff out, I was just focusing on getting my stuff out. Once we were there, I did see that they had his things. I didn't want to go back. I didn't tell them to take it back. I just didn't know what to do at this point.
So how did you get involved with the police?
How did I get involved with
Yes.
the police?
Did the police, because I see where a neighbor said, oh yeah, she's the one. So I'm assuming the complainant picked up the phone and called and said, she took my items. So where does this come in with you giving the police a statement?
Because once I realized I had made a poor judgment and I was not in a safe environment, I called Francisco back and I tried to work things out with him. He told me that I could come back home and told me to write out a statement. So that's what I did.
So, and let me see if I'm following it along. So your story is there were some issues with Francisco. He calls the police to his home. When he calls the police to his home, he's the person who gets arrested. And then when he's arrested, you call 3 friends or however many friends to come over, move items from the house. And it appears, and if I'm wrong, correct me, it appears that all of his items were taken. You leave with these people. And then the complainant is released from the Bexar County Jail. He goes back to his house. His neighbor tells him all this stuff is missing. You're with these other people and you say, this is a bad situation I'm in with these other three people. So you pick up the phone and you call Francisco back and tell him that you want to work things out. And then you go back to his house and then you write a statement saying what you took. All right. Any other questions?
No, Your Honor.
All right. Any other questions?
No, Your Honor. I would like.
Things just took a somber turn. The defense is bringing up a history of domestic violence. In the legal world, this is called mitigating evidence. It doesn't make the theft legal, but it helps the judge understand the why behind the panic. We're transitioning now from Melanie's case to a 19-year-old who is about to learn a very hard lesson about what happens when you put your darkest thoughts in writing.
Point out in the PSI does have a bit of her past history, and I'm not saying that this is an excuse for her actions on this particular case, but I do have to point out that she has been victim of sexual and domestic violence throughout her lifetime at the hands of various men, including the complaining witness.
All right. When's the last time you had contact with the complainant?
It's been about 8 months since I was arrested.
Okay. State? You're opposed? Why you're opposed?
Good question, Your Honor. I don't think that worked out the plea agreement, so I don't know the thought process of the prosecutor did.
All right. You want to discuss with them and see if they're still opposed? All right. If you'll step back, they'll speak, then we'll come back. All right. We are back on the record in 2024, CR 2482, State versus Melanie Barone. So where we left off, State, you were opposed. Is that correct?
Yes, we were at this time. State changes. Opposed to silence.
All right. Any objections to the state's changing the plea bargain agreement?
No, Your Honor, no objection.
All right. If you're drug tested today, what would the results be?
Negative.
And states came to an agreement on the amount of execution. It is $20,000.
All right. Thank you. All right. This is what the court will do. The court will sentence you to 4 years deferred adjudication. There's to be mixed supervision, and that's based upon the evaluation the court is in receipt of. There's to be no contact and restitution of $20,000 to Francisco Vasquez. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's going to be 100 hours of community service restitution. Do you have any children?
No.
All right. I'm going to order your trauma classes probation. Once she completes those, the community service hours will be deemed satisfied. There's going to be field visits 1 time per month for 6 months. And then at probation's discretion. There's to be a $1,500 fine, and that will be probated. Probation, is there anything else she needs? Is there anything else you need from the court?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney?
Yes, Your Honor.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. In this court, to be successful, communication is key. If there's an issue and you feel as though probation is not addressing it, you can always come back to the court. Do you understand?
Yes, Your Honor.
All right. Any objections to the court changing the agreement to include the fact that the state was silent?
No objection, Your Honor.
All right. All right. Probation will go over conditions with you. And once you've completed that, you're excused.
Thank you, Your Honor.
Thank you.
Judge, thank you very much.
Did you understand the state is proceeding on the lesser included offense of terroristic threat as a Class A misdemeanor? The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty as you apply for deferred adjudication. Are you proceeding in sentencing?
Yes, Your Honor.
Yes, sir.
All right. Anything you wish to say on behalf of your client?
Yes, Your Honor. Mr. Lopez was in this situation. He was being bullied at school, Your Honor. I would like to say that the state's exhibit number 1, which tags the high school, was not actually done by Mr. Lopez. It was a story he shared and then shared by another student that tagged the school. So that may be a little misleading based on the picture itself. But he did not tag the school itself in that exhibit. I just want to let the court know.
Thank you. How old are you?
19, Your Honor.
All right. You're 19. So, and I'm assuming this person, Santanella, was that your friend?
Who, Your Honor?
Joe Santanella. I know Santaniana. It's 2 L's.
Santayana.
Was that your friend?
No, sir. No, Your Honor.
He's never been your friend in the past. All right. So who was Victoria to you?
Just somebody that we knew through Joe.
I'm sorry?
Somebody I knew through Joe.
All right. So everyone, we're on the record. Don't talk behind the court reporter. So that's someone you knew?
Yes.
All right. So it seems from reading the reports that it was more than just someone you knew. This was sort of like a love interest between the two of you.
Yes, ma'am.
All right. So here's the thing. You need to be 100% honest with me. You understand?
Yes, ma'am.
So I don't know why people who are in high school or in middle, well, I don't even understand the dating, serious dating in middle school. I guess I'm aging myself. That just was not allowed. But when you're in high school, maybe it's the love of your life. Maybe y'all going to end up getting married. Maybe not. From what I've seen in this world, usually those are just, we're just dating. They're just experiences. And then you move on. You understand?
Yes, ma'am.
She doesn't want you in that way. I don't think she wants to speak to you at all. So you're not allowed to talk to her. Do you understand?
Yes, ma'am.
Are you still going to this high school?
No, Your Honor.
All right. And Joe, don't want to speak to you. You're not allowed to speak to him at all. You understand?
Yes, ma'am.
And here's what I can tell you. When you have a relationship and your best friend starts dating the person you're in a relationship with, usually that's not your best friend. That's not a friend. Because if that person were your best friend or your friend, they would tell the other party who wants to date them, no, another time, another place. It's like Erykah Badu, see you next lifetime. I'm with somebody else right now. You understand?
Yes, ma'am.
So you're going to be hit with a lot of things in your life that you think are not fair, but you got to roll with the punches and keep going forward. You don't put stuff in writing.
This is the mom talk of the century. Judge is dropping some absolute gems here. Don't ever put anything in writing that you don't want the entire world to see. In the age of screenshots and social media, this is the best legal advice you will ever get for free. The defendant, Nicholas, is realizing that a high school grudge just became a permanent part of a state record. Imagine being 19 and having a judge read your own slurs back to you. Talk about a wake-up call.
You understand?
Yes, ma'am.
And in your writing, you're using the N word. I bet you were shocked when you saw me here. Right?
Yes, ma'am.
So this is what I was always told. This is what my mother's teacher told her when she was in school back in the, back in the 50s. You know what she always told them? Don't ever put anything in writing that you don't want the entire world to see. You understand?
Yes, ma'am.
Now, the fact that you're using the N-word, I'm not holding that against you. Young people are just doing crazy, stupid things. That is not an appropriate word to be using. Do you understand?
Yes,
I don't care what people are doing in rap or whatever. MC Light said that she was shocked when she went to a club when people started calling females the B word and using the N word. She's like, when I started out in rap, people were not using that language. Not good language to use. Do you understand?
Yes, ma'am.
And it's not good to make threats against people. When your heart is broken, I don't care if it's breaking in 1,000 pieces and you want to cry. Guess what? The person who broke your heart, just look in their face and smile, and then go back to your room, go talk to somebody that you know, your mom, your dad, and cry it out there. You understand?
Yes, ma'am.
Are you employed?
Yes, Your Honor.
What do you do?
Construction, Your Honor.
All right. What are your plans for the future? What is your dream job?
Construction, Your Honor.
Well, look, you're on a great path. You're already doing what you want to do. How far did you go in school?
11th grade, Your Honor.
All right. You're going to have to graduate. Okay.
Yes, ma'am.
And then if you really want to be in construction and hope to move up, sometimes people will be in construction and things will fall into your lap. Next thing you know, you're owning a company. Education never hurt anybody. If you want to end up owning your own company, you can, but you probably should take some business classes. You understand?
Yes, ma'am.
All right. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's to be no fine. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be no contact with, and do you have any reason to be at Wagner High School?
No, Your Honor.
All right, there's to be no contact with Wagner High School. Joe Santana, Santellana Jr., Victoria Hernandez. And of course, you're not allowed to possess any firearms. I'm going to order 80 hours of community service restitution. If you obtain your GED, or if you obtain some type of trial, trade school certificate, or if you take a business course, I will deem those community service hours satisfied. Do you understand?
Yes.
There's going to be field visits 1 time per month for 3 months. There should be proof of employment within 45 days. There should be no employment as a home health care provider or with minors. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Thank you so much for dressing appropriately for court. And what is your name again?
Nicholas Asaro.
Nicholas
Asaro?
Asaro?
Yes, ma'am.
All right, everyone, this is a student attorney, Nicholas Asaro. Give him a round of applause. He did great. Come in anytime you want to. What level are you at in school?
So 3L.
3L. Oh my gosh, you're almost here. All right,
Yes,
thank you. So what will happen is probation will speak to your client and go over conditions with them, and then you all are excused.
Yes, Your Honor.
All right, thank you. 2 years deferred.
Your Honor, Alexander, on behalf of the defendant, she was also present there, Daniels.
Daniels.
Yes, sir.
All right.
Run. If I may, of sir. I said something. Good luck.
Maybe. Whatever. Go ahead. What do you want to say?
Last time I was here, I was scared. And I lied.
Okay.
I wasn't honest. I went through this with Mr. McLaughlin. I did not. When they wouldn't let me into my place. And so I took the money.
Both sets of money? Both sets?
I took money. Because I had no place to go. And I didn't know what to do. And I had medications and I was on the street. I had no family and friends. And he kept pressing me to move on so that someone else moved in. And he kept sending me emails and texts that my security deposit was going down. And I really didn't know what to do. And being not able to get back to my place where my stuff is, I was scared. I truly was. And I didn't want to admit that I was afraid or something like that. You know, so I thought maybe it seemed like I'm weak or something like that. I found out that it makes me seem like I'm weak by not being honest. Yeah, I apologize. Please skip it.
So you voluntarily surrendered the apartment.
No, I disagree with the apartment. No, I couldn't get back in there. They had already locked the doors. I couldn't get in. I couldn't get in. They're standing there. I couldn't get in.
So what are you claiming you lied about?
I accepted the $400.
Which $400?
There's only one.
Well, no. My understanding is there's two $400.
That's what I'm trying to say.
Okay, so which $400 did you lie about?
A $400 video that they had showing them giving me $400. This video.
From Mr. McLaughlin's agent.
Yeah.
You took that $400.
Yeah. He came down the stairs and they gave it to me.
Okay.
I didn't want it, but.
Well, hold on a second. Hold on, Mr. Daniels. So you took that $400, and that was the $400 where you agreed to surrender the unit.
No, I didn't agree to surrender anything.
Then why were you getting the $400?
He told me, Daryl, listen, you might as well. And I agree with him. Never looked at me. I'm not signing anything. Very strong. He's like, yeah. He said, I don't need to him already.
Well, so
I was frightened.
Daniels,
Yes, sir.
there's this meeting that takes place.
Yes, sir.
You're given $400.
Yes, sir.
Why did they give you the $400 if it wasn't to relinquish possession of it?
I wasn't relinquishing possession.
Okay.
I never agreed
Then, okay. All right. Then why did you take the $400?
I didn't know what to do. I had no place.
What do you mean you didn't know what to
I
do?
didn't have no place to go. And I don't want to stay on the streets. And
Mr. Daniel,
yes, sir.
what you're saying, it doesn't make any sense. So, you need to start telling the truth. So,
I took it because I didn't know I had no place to go. I didn't have no money to get food to eat. I had medications that I had to have.
Mr. Daniel, you had a place. They said, so here's what you told me.
The door was locked. I was locked out. I had the keys to the place. The locks were changed. I had no way of getting in. And if you show the video properly, even the front door was supported shut. It was X cross with wood. I couldn't get in. The locks were changed and all that. I come around to the back, and there they are standing at the back door. And I'm like, listen, let me in. And they're like, no. And I was like, I was scared, it's like, no excuse. I do a lot of mental illness, mental things, and I thought that they all coming in anyway. They had broken into my home while staying there, and the tenant that stayed there, I told him to walk. He's like, so what you want me to do? And I was afraid, honestly. But I was afraid that I would react in a way that I was supposed to. I didn't know what to do. Honestly. I did. Truthfully. I didn't know what to do. And not thinking properly and thinking that I would be smarter than them, accepting it, still become reported this something what they've done. That's what I thought. I have been truly, at the time, everything was happening. I was panicking, and didn't want to go through it, didn't want to go on the streets, didn't know what's happening. And they offered money now. That's okay. I thought I was being smart. I apologize. I didn't know what I was doing. I was very scared. I was trying to be able to come here and tell what they were doing to me that was wrong. Because I was already locked out. The locks were already changed. I thought I was fine. I did. I apologize.
Mr. Daniels, what do you want me to do now that it's been determined, well, you've admitted that you've lied?
I was already back, as I stated. The locks had already been changed. I was locked out. I want to be treated fairly, done right, but I did that to myself like they did.
Well, that's interesting. You want to be treated fairly because,
I treated myself.
well, quite frankly, this isn't about you because you came here on the date the hearing was set. Mr. McLaughlin was not here. You told me they had locked you out,
Yes.
that you could not get back in your
Yes.
premises
Yes.
and all of that, right?
Yes.
That basically he had resorted to self-help.
Yes.
What that led the court to do was to then set, but now I understand why Mr. McLaughlin was here because you had surrendered the apartment.
No. The doors were already locked. The locks were changed. The locks were already changed.
So then I show cause Mr. McLaughlin to come in. He files an answer. He files a response.
Yeah.
We are back here. You go and get legal services. Mr. Henry appears.
Yes.
And at that hearing, you continued to maintain that you were locked out.
Yes. Yes.
And specifically told me that you didn't take the $400.
I lied.
I know. We get that you lied. But that you didn't take the $400, that they locked you out, that then there wasn't this period in time afterwards.
Yes.
You got community mental health because of that to put you up.
Yes.
So other monies got paid on your behalf.
Yes. They did change the locks on the door. I couldn't get in. The locks were changed. I couldn't get in.
Tell me why I should believe you.
Truly, Your Honor.
What?
Not telling you the first time it came where you shouldn't.
I shouldn't believe anything you are telling me. I do not believe.
I understand. But I couldn't go on after, sit back praying and think about it. And you've been honest with me, you've been fair with me all the time. And I couldn't
What I do.
tell you no lies. And I had to come tell you today and let you know that. I was afraid. I was
Afraid of what?
I don't know everything. I was locked out and the locks changed already when they gave me the money. They're all changed. I'm locked out. And I thought it was based on something else. Apologies. If you could, I won't say anything else. That might say what else I say. But I was being honest. I'm just, now I am. I like
You know something? Not only did you lie to me, you recall at the last hearing, I had my bailiff put Mr. McLaughlin under oath, and we put you under oath.
Yes, sir. Yes, sir.
Mr. McLaughlin maintained the same story that he basically had put in his written communication and what he had said. He didn't have everything with him. He said he had a video and wanted to make sure that he could bring it next
Mr.
week.
McLaughlin have not been honest.
Oh.
That's why every time I call other people I was trying to move out of Mr. McLaughlin's place because I didn't like it there.
You surrendered possession. You surrendered possession of
No.
the premises.
No, sir.
Yes, you did.
No, sir.
Yes, you did. That's why you took the $400.
Your Honor, as I stated, the locks were changed before they gave me that. The locks were changed.
I don't believe you.
I know you. That's right, I can tell you the truth. The locks were already changed.
You know something, Mr. No.
And here it is, the moment the web of lies unravels. Mr. Daniels thought he could play the court, play legal services, and play community mental health for a free stay, all while pocketing cash for Key's money. The judge is at her limit. When a judge says, "Be quiet," and mentions the bailiff, you are one breath away from a jail cell. This is a masterclass in how not to act in front of a magistrate. Honesty might be the best policy, but for Mr. Daniels, it might have come about 30 minutes too late.
Be quiet.
Pardon?
Be quiet. You lied to this court when you came here, caused me to file an order to show cause, got Mr. McLaughlin in. Mr. McLaughlin had to file an answer to it, find all of that information, do all of that. You go to legal services, they in good faith, Mr. Henry decides to represent you because you're saying that you've been locked out of the premises. We get here, for the second time that you've been here, Mr. McLaughlin was only here the one time, but we all get here, put you under oath, you give me your story, the story you give me, you lied. Now, in that same time, you are also lying to community mental health, who is paying to put you up as though you had been locked out. You were not locked out.
Locked out.
No, you weren't.
When he gave me at this whole video, I go upstairs. I'm beating on the door to get in. And I said to the gentleman, "Got to give me $400." The locks are already changed.
If that were the truth,
Yeah.
then why wouldn't you have told me that you got the $400?
The same as the same as going.
Why would
I apologize. I have no excuse. I have no excuse.
your story just keeps changing? Your story keeps changing.
I was home last year, and I had medication stuff that I didn't have, and I had no place to go. I had no family with friends. That's why I was trained. I had no place to go. As he showed the video, the doors were locked. The locks were changed. They've already changed the locks. The locks were already changed. And I told him to come down and give me $400. The locks were already changed from the door. I couldn't get in.
Good. You tell me everything you want to tell me.
That's all
Because I don't want you to ever say I didn't give you a chance to tell me.
told you everything. But the locks were already changed on the door. They came down and gave me the $400, sir.
And I don't believe
And I took it.
And I don't believe you. I think that what happened here is you took the $400, voluntarily moved, which also then makes sense with what Mr. McLaughlin was saying and what he has in writing, that he agreed. You know what? I am not going to sit here and try to overtalk you, because if you keep interrupting me, you're going to be going with my bailiff. Am I clear?
I'm not an aggressor. So, I'll leave it if you want me to. Sorry.
The reason you took the $400 is because you voluntarily surrendered the premises. That's what the court's going to find, that you did that. And that you court also believes that you took the additional $400 that was later on given to you. It all makes sense. That's why Mr. McLaughlin said, I will keep, and it's in writing in a text that he would allow your property to stay there for a month. And then he gave you more money. And you're just taking money and then coming to court, causing everybody all kinds of problems.
I know how to do it.
Oh, no, you don't even have any idea.
I took loss. Sorry.
You keep interrupting me, so I'm done.
I didn't see Roxy at fault.
I find that there was no lockout. I also find that he voluntarily surrendered the premises. Mr. Henry, I know this is embarrassing for you because you came here representing your client, believing that all of this had happened. I find you and have found you always to be an honorable attorney and always put good faith arguments. And you properly did the right thing once you determined your client was an absolute liar. And that is you filed your motion to withdraw. So prior to entering what I'm entering, I'm going to grant your motion to withdraw. Find that it's surrendered. This case is dismissed, but you are entitled to possession of the premises. Oh, yeah. It's yours. He gave it up. You want to know what? You keep it up. What did I tell you? You think I'm kidding? Do you think I'm kidding? Then I'd suggest what you do is you turn around and you walk out and don't say another word to me, because if you say another word to me, you're going to go with Officer Mahoney. Have a great day.
Places.
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, family violence as a Class A misdemeanor? Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. So,
Judge, it was a plea bargain for 1/2.
oh, 1/2, because I have the document he signed was for deferred or community supervision, but I see your plea is 1/2.
Correct.
So this is what I want to ask. Number one, what's the result of the CPS case?
The child is with him. This is his biological grandchild. It's an incident from 2020. She was continually running away, and there was a little bit of perceived excessive discipline on her behalf. His wife is also charged. They're going to be dismissing that case.
Okay.
But the child is living with him, and I don't believe the biological parents are involved.
All right. So how long since this incident has the child been living with him?
She was 6 years old when we first got her.
No. I mean, since this incident, since this assault.
The same, that was 22, right after that, a couple of months, they brought her back.
So she was only out of the house for a little bit.
Yes.
All right. So is the CPS case closed?
Yes.
State CPS case closed?
That's my understanding as well, Your Honor. Yes.
All right. And so she is living with them?
Yes, Your Honor.
She is 16 now.
She's 16. Okay.
She's going to school, so that's what mattered to me, going to school.
Regis.
Yes.
The court is inclined to offer you a deferred adjudication. Off the record, I've been told that your criminal history is almost non-existent, really. But if I offer you deferred adjudication, if for any reason your deferred adjudication were revoked, I want you to know that I could sentence, I know I've told you this before, but I want you to know that I could sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine. Your agreement with the state is for a conviction.
Yes, ma'am.
So do you wish to have the conviction or deferred?
No.
Deferred or the conviction?
Deferred.
All right. So this is what the court is going to do. The court is going to sentence you to an affirmative finding of family violence. I'm going to ask for parenting classes, but probation, if parenting classes have been previously completed under CPS, that will be deemed satisfied. I'm going to ask for field visits one time for 3 months. And probation, if you'll make sure they have a chance to check on the teenagers in the household and talk to them separately to see that everything is okay. And then it will be at probation's discretion. There should be no harmful or injurious contact with Star Rodriguez. And off the record, both parties told me that this is a case that occurred in 2020. And of course, it's only recently come to this court. So it occurred in 2020. It was indicted in 2024. My understanding from both parties is that Child Protective Services closed this case. And in order to close the case, Mr. Rodriguez had to complete parenting classes. From reading the state stipulation, it appears that the child's mother, who was released from prison, was allowed to see her child. And then after she saw her child, that's when issues would arise. Am I correct in my prediction?
That is accurate.
All right. Court is going to sentence you to 6 months deferred adjudication. There's to be regular reporting by Zoom or in person. And there's to be regular random UAs, 80 hours of community service restitution. And if it's shown that he's completed parenting classes, then that would be deemed satisfied. Are you employed or retired?
Retirement.
All right. From what? What were you doing?
Northside School District.
Okay. All right. Probation. Is there anything else?
No, Your Honor.
I was asking probation, but I appreciate you for saying there's nothing. Is there anything else you want me to add to his conditions?
I was going to ask if you could lower the probation fees, because he's on a fixed income. Him and his wife, they just live off of Social Security and a small retirement.
All right. So what will he need to do legally? He'll have to speak with probation about that. And if he does an affidavit of indigency, then the court could work with that.
Okay.
All right. Did you review? Is there anything else you need from the court?
No.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. Is there anything else from either side?
No.
Mistake, Judge.
All right. Good luck to you.
Thank you.
Just remain in the courtroom. Probation will go over conditions with you.
Thank you, ma'am.
Can I see the file on Lucy Rodriguez?
What's
that?
You're sitting in my first bench or whatever.
You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. This year's not been a very good year for you, man.
Yes, sir.
You now stand. You also have 2 open aggravated assaults against a public servant. All right.
On August 18, 2024, in Harris County, Texas, officers responded to a disturbance in the 19400 block in 45 freeway. Officers came into contact with the complaining witness and learned that the complaining witness's boyfriend interfered with the complaining witness's ability to call 911 during argument. The complaining witness stated that she and the defendant were arguing about relationship issues, and the complaining witness is 3 months pregnant. The defendant was driving the complaining witness's car during the argument, and at some point they pulled over at the residence. The complaining witness asked the defendant to exit the vehicle before she called 911. The defendant refused to exit the vehicle and grabbed her phone and began to dial 911. Where the CW began to dial 911, that's when the defendant reached over and took the complainant's phone. And while doing so, the defendant disconnected the 911 call. The complainant then grabbed the defendant's phone and dialed 911. The defendant then removed the complainant's car keys from the ignition, moved the complainant's phone and keys away from her, and walked away from the scene prior to officers arriving. Upon reviewing the 911 call, the officer could observe the complainant yelling stop, and also hear a struggle while the complainant said, "Let me go, Kevin. Oh my God, what is wrong with you?" The phone line stayed open for approximately 14 seconds longer. The second call begins with the complainant crying, hyperventilating, and stating that she got into an argument with her boyfriend. The complainant then stated that the defendant put her hands on her when she took his phone to call the police.
What happened with the aggravated assaults? And I guess my other question, any alcohol or dope in this one here?
There's no allegations in this current case. And
Okay.
aggravated assault, they're still pending, Your Honor.
Sure. How bad? Are we talking, did he shoot someone, point a gun?
I can briefly tell you, Your Honor.
Yeah. You're representing him upstairs?
Yes.
Great.
And it was basically two officers that were directing traffic off duty. He didn't see them. He lives near a mosque and there was all this traffic and he laid on the horn and then the guy like grabbed the door to open it and he drove on it. And then, so one guy's claims his hand was hurt and then another officer stepped in front of him. He said he
hit the officer.
What he claims. But
any injuries?
No.
Mr. Geenan, I'm going to find Mr. Geenan, I'm going to find that there's probable cause to go forward with the case. I'm now setting your bond at $5,000. So, what about the relationship now? You know, at the end of the day, you need to distance yourself from anyone and everyone in your life that could potentially put you in jail. Because just listen, you know, if it's the type of relationship that you're constantly butting heads like two billy goats, it's probably best to get away. Especially being that she's pregnant, she's hormonal, she's going to be moody, you know, she needs help, her feet swell, you know, and at times will be extremely stressful. If you're the type of person that loses it and just can't, then don't. Because you're the one that's going to end up in custody. Your bonds are $70,000 now. You violate these conditions, you're going to end up with a $500,000 bond.
I will say he's in counseling, Your Honor. We're going to make some changes.
I think that's a great thing. If you truly are, the idea is, and I'll tell you that I would say 90% of the jail population in custody now are there because they have no self-control. They just wig out, flip out, and do whatever without thinking of consequence. And that's why they're in there. Do you have any clue what they would do to you in prison? Take a guess. You'll be someone's bitch real quick. Really. It's not fun. And I'm telling you, I've read stuff that turned me white. It was as bad. It had me in damn near tears because it's so bad.
Yes, sir.
In prison. And you? So, state, as far as contact with the complaining witness, what do you guys, have you been able to rip? Do we know that she wants to have contact? I want to honor her with, until I know that she wants to have contact with him, I'm going to order no contact because I don't know what she wants and I want to honor her wishes. I want you to know that I am entering in what's called a protective order, if there's not one in now. Let me see. This is a protective order that identifies, is it Evadne? Is that right? Evadne DeCruz as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. This, if you violate this, they will file an additional charge against you. So be very careful. I want to know what she wants. So if you guys can get the phone number to them and they can get the rip done, then we can modify these conditions today, and I'm happy to do it. Just
understood.
As it stands now, the only way we're going to release him is you have a bonding company here now?
Yes, they're on their way.
Okay, so you're going to stay with us until we know that a bonding company comes, and then we'll have you sign conditions. Okay, I'm ordering you now, don't consume alcohol or drugs. I'm going to randomly test you. If I find that you use any kind of alcohol or dope, I'm going to put you in jail. You will not get any more PR bonds from me. Do you understand?
Sir.
Okay.
Is it okay if you sit in the
Yes, we'll have him sit in the jury box now. And then just, if you can get.
I will.
Yeah, I know. I got you. Thanks.
Thank you, Judge.
Yes, sir. Sir, you're charged with driving while intoxicated. You're facing 6 months in jail. Sorry, is it Class A? You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer, the lawyer will be appointed to represent you, sir.
Yes, Judge. On September 12th, 2024, officer was traveling westbound on the South Sam Houston Parkway, a public roadway in Harris County, Texas, when the officer observed a stopped car in the third moving lane of traffic with its lights off. The officer found the driver to be asleep in the driver's seat and made contact with the driver, waking him up with his flashlight. The officer observed him to be confused, unable to unlock his door, and upon opening the door, the officer observed glassy eyes, slurred speech, and the odor of an alcoholic beverage emitting from the defendant's person. The defendant admitted to coming from a party where he had been drinking. The officer detained the defendant and relocated the scene to a nearby parking lot for scene safety. The defendant consented to a standard field sobriety test, HGN 6 out of 6, walk and turn 8 out of 8, one leg stand 3 out of 4. Defendant was read the DIC and consented to breath. The defendant blew a 0.167 and a 0.168. Defendant found to be on bond for DWI out of Fort Bend County from 2024.
He's on bond right now for another DWI.
Yes, Your Honor.
Oh, hell no.
Leave on, Your Honor. It looks like it may have been disposed. I'll check.
Please.
There's no disposition known in the NTSC, so I don't know. It's just open. I can see if the officer.
Is your DWI currently open in Montgomery County?
Or Fort Bend County.
Or Fort Bend County?
Yes.
They gave you a PR bond in this case. I'm taking away your PR bond, sir. I'm taking you into custody now. And I'm going to tell you now, I'm taking away your privilege to drive and I'm giving you a curfew so you're not out in the middle of the night, and I'm going to put an ankle monitor on you. If I find that you're out in the middle of the night or you consume alcohol, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you either get in a car and drive, consume alcohol. I will have a hearing. If they prove it to me, I will slap you with 180 days. And if you continue to consume alcohol, I will put you in a rehab facility. If I find that you drive a car, then I'll put you in jail for up to 6 months every time you drive. Do you understand?
Yes, sir.
Don't send him down, please, because I'm going to need him to sign a whole host of conditions. We were talking about you, so it's only fair that you hear what's going on. You know, it seems that you had a pretty sweetheart deal, it looks like, in Fort Bend, and now all that has gone through the tubes. I've known him for a long time. I've known him for at least 20 years. Great working relationship, and I love the way he works. And he's asking me to either give you a PR bond or a low bond. And I'm thinking to myself, why would I do that? Because you do whatever you're going to do, and you don't care what anybody else says. Why would we bend over backwards to help someone like that? Why? Just because you're sorry? Actions speak louder than words. You telling me sorry. You telling me I'm never going to do this again. We heard that before. And where we are now. Tell me what you would like.
Judge, I'd like you to consider a $500 surety bond. He's already on $6,000 in misdemeanor bonds and complying with those conditions. I'm not saying he was complying, but I'm saying now he's going forward complying with conditions. And he can only operate now a vehicle with an interlock device, and your condition right now says no driving. I'd like to address that, but on the amount of bond, if you would consider, he makes $300 a week. He works for his dad. They do driving things. They
And you don't.
Well, he's a courier. He wasn't a courier this night in question. So then
go ahead.
So you have that tool, it sounds like, no driving. He lives with his grandmother. He has some bills, and he makes about $1,200 a month. Right now, he's spent what he has And he has to reach out to other family members for any kind of assistance. And he has a good family there, certainly want to help, but they don't have a lot of means either. And he's going to have to deal with Corbin now in a way that he's probably going to hopefully get a straight probation out there and work something out here in some form of fashion at some expedition point. There's some issues in this case, but
Mr. Thompson, I want you to understand that when I have someone that comes into my court with multiple DWIs, I usually set bonds somewhere in the neighborhood of around $15,000 to $20,000, if not higher. That's what I normally do. When someone has 2 open DWIs, I always take their privilege to drive away from me. Why would we put and endanger the streets of Harris County when you have repeatedly shown that you failed to care about any bond conditions? You've repeatedly shown it. So I'm sorry, Troy. I'm not going to let him drive. He's got 2 open DWIs. Not only that, but I don't want him out in the middle of the night. I'm going to give you a curfew. And I'm going to, on one ankle, I'm going to put a scram ankle monitor so I know that you're not consuming alcohol. On your other ankle, you're going to get a GPS monitor so I know that you're not out in the middle of the night. And I'm going to tell you now, if I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail every time you drive. Do you understand?
Yes, sir.
Hopefully now we will get your attention. And to me, if you think that you're going to garner any sympathy because you live with grandma or they make $100 a day, nope. Luckily, no one was really injured, because then you would really be up Shisa Creek. And then you'd really be in custody with bonds in the quadruple to quintuple digits. I can't, because $500 is something that we give to someone on usually a first offense. I have another guy here with another DWI, a $500 bond. Someone who has 3 open cases, 2 of them being very dangerous cases. I can't possibly do that. And I'm going to tell you, quite frankly, you're lucky that it's now only at $5,000, because ask them. I always set it at $15,000 to $20,000 on a second DWI. So if you now get a taste of jail, perhaps that's what it needs. I will say this, Troy, that I will waive the fee on all of his devices that he's going to have, because that'll save him a pretty penny right there. I'm waiving all your fees, which right now, garnering everything that I have on you now, is probably going to be around, $1,200 to $1,500 a month in fees that I'm waiving. So, and because so, I will not entertain any excuses from you. Do you understand? All right. Good luck. We got it. Thank you.